everyone, can we please be seated to start our session for today? And can I request our guests and friends who are outside having tea to please come inside?
Everyone, I would like to invite Mr. Shyam Diwan, Vice President of BII, to chair the session. And I would like to invite the speakers, Mr. Vikramjit Banerjee, Additional Solicitor General of India, to come onto the dais. I would like to invite Mr. B.V. Acharya, Senior Advocate, to come onto the dais. Now I invite Mrs. Mukta Gupta, Senior Advocate, to please come onto the dais. I would like to invite Dr. Kumar Askand Pandey, Associate Professor, RML University, to come onto the dais, please. Now I would like to ask Mr. Shyam Diwan to chair the session, and I'm sure after the end of the session there would be clarity and there will be more adaptability, and we are ready for the taking on the new penal codes. Thank you.
A very good morning to each one of you. Thank you very much, Srinivas. It's my honor and truly a privilege to be chairing this session. It promises to be an extremely important session because it's going to be a learning for each one of us here in the audience. And I suspect it's going to be a learning for those on the dais as well, because this is a new statute and there are so many new perspectives which are to be discussed, which are to be debated. I'm going to depart. Usually I begin by saying that we're all going to sort of, everyone on the stage is so well known that doesn't require an introduction. But today I propose to read in some detail the CVs of the very distinguished people we have over here. And the reason that I wish to read their CVs at length is because of their extraordinarily rich experience in the field. And I cannot imagine, and I truly commend the organizers for bringing together this particular panel, because it's a rich and varied experience in the subject of criminal procedure and all its various dimensions. What we have over here on offer is persons who have an experience as practitioners and as lawyers across a range of roles at the bar. We have experience from the bench. We have experience from the academic perspective. And this really are the three primary braids which will make for an effective administration of any criminal statute. I don't have very much in terms of the opening remarks, but since these, actually I now notice that there is a mobile sort of microphone close to my desk, but I thought that there was just going to be this, so I thought I'll just sweep through the CVs of the various individual speakers, the eminent speakers. And I thought I'd also do that because probably the audience, 10 o'clock on a Sunday morning is quite a task. So it will take a little time for the hall to fill up. So our first speaker is Mr. Vikramjit Banerjee, who is Additional Solicitor General of India in the Supreme Court. He graduated from the National Law School in 1997. And you will notice when I come to Mr. Acharya's biodata that he was long before that a designated senior. And so we have a very, very rich variety here. Mr. Banerjee owes me a book. He is the co-editor of a 2008 book titled The Truth About Teesta Settlement and I am very, very anxious to read that because I have read her volume on Foot Soldier of the Constitution, which I commend to each one of you. But I suspect that Mr. Banerjee's edited volume has a different perspective, and he should immediately sort of share the link so that we can all order it on Amazon or whatever if he's reluctant to present each one with a copy. He was appointed as Advocate General of Nagaland in 2015, designated as a senior advocate by the Guwahati High Court in 2016, of course, as we know, designated by the Supreme Court of India. Now, this next part, apart from his great competence as a law officer, I can attest to. And the next part is that he regularly delivers lectures at international conferences, at conferences organized by universities and institutions. And each one of them has a rich array of perspectives. And I can assure you that he puts in a huge amount of work even before sharing those perspectives with the audience. And his interests, of course, extend much beyond the law to aspects of culture, religion, and he has written and authored several articles in this regard. The second speaker, as we go through the panel, is the redoubtable and formidable Mr. B.V. Acharya, who is sort of a living legend of the law. He's been so recognized by the Bar Association of India. He's, of course, a member of our family. And he was born in Udupi district. And, well, when I was looking at this statute, I was wondering how do I connect this to Udupi. And I then saw that the statute which we are discussing is the Bharatiya Nagarik Suraksha Sanhita, which sort of abbreviates into BNSS. And frankly, I thought of BNHS. I don't know how many of you are familiar with BNHS. I can see Mr. Varunjikar is certainly familiar with BNHS and several others. So it first struck me that now BNHS is what I am going to sort of talk about. And the BNHS is the Bombay Natural History Society. It has a connection to the law. It's absolutely a premier society which engages in all aspects of natural history. It was set up in 1883. And its connection to the law is that one of its founders was John Duncan Inverarity. I don't know whether any of you have heard of Inverarity, apart from the Bombay lawyers over here. But he was a legendary barrister. And the Chief Justice of the then Chief Justice of the Bombay High Court, so we're talking about 1883 and thereabouts, said that he dominated the profession in the Bombay High Court for 3 decades. And in the Bombay High Court on the ground floor, there's a plaque, because at that time the council's chambers were part of the High Court building on the ground floor. And there's a plaque recognizing this formidable person. And in Vacha's book, there's a whole lot about J.D. Inverarity. So we thank, so that's the connection of BNHS and the law. And of course, I keep on my desk a volume of the Migratory Atlas, which is a brilliant book which has come out of, published by BNHS, which shows the migratory patterns of all these birds, across India. And my favorite is the South Polar Schooner. Now, why do I raise the South Polar Schooner? The South Polar Schooner was ringed. It was given a ring by the US Antarctic Research Program. And it traveled 17,500 kilometers, that's the direct route, to land in Udupi. And it was unringed over there. So you can just imagine the stamina of this incredible bird and the journey which it made over 17,500 kilometers. Now, we're not very sure as to whether that is a pattern which which the schooner follows regularly. But we have to sort of link up as to, whether birds, I mean, are we going to be free birds? Are the birds going to escape? Are the birds going to be entrapped by the new Criminal Procedure Code, or rather by the BNSS? Or are they going to sort of, remain as it were in terms of their migration from one jurisdiction to the other? But returning to Mr. Acharya, he was chairman of the Karnataka State Bar Council between 79 and 82, designated as a senior advocate by the Karnataka High Court in 1989. In December 89, he was appointed Advocate General a post he held 5 times between 1989 and 2012. In 2005, he was appointed as the Special Public Prosecutor in the disproportionate assets case against Selvi Jayalalitha, former Chief Minister of Tamil Nadu. And then there's a whole line of honorary doctorates and other distinctions. And in November 2014, he published his autobiography, All from Memory, which was released, and a second volume, Memoir of a Prosecutor. So I'm very much looking forward, as I'm sure each one of you is as well, to his presentation because it's so rich. And at the sprightly age of 88, Mr. Acharya is here. We welcome him. We thank him immensely for his presence with a round of applause. And I thank you, each one of you. For many of us, he's been a senior advocate for longer than he was an advocate, and longer than many of our careers. We then have the redoubtable, now I don't know how to say this, should we say Justice Mukta Gupta, or should we just say Mukta Gupta Senior Advocate? Because, justice is something which remains with you for life. It's a great distinction which society and indeed the Constitution confers on you. And we're very grateful to her for sharing with us her time. She graduated from securing her LLB from the Campus Law Center in 1983, was enrolled by the Delhi Bar Council as an advocate in 1984, and practiced in a range of civil as well as criminal cases. Now, this next part is very important. She was appointed as the Standing Counsel Criminal of the Government of NCT of Delhi in the Delhi High Court in August 2001, has conducted many criminal cases, including the Parliament and Red Fort shootout cases, the Jessica Lal murder case, the Naina Sahini murder case, the Nitish Katara murder case in the High Court and in the Supreme Court, and had been a counsel for the All India Institute of Medical Sciences. So you cannot get a better speaker or a speaker with a richer and a more varied experience. She was special counsel for the CBI in cases like the Naval War Room leak case and the Priyadarshini Matu murder case, the Madhumita Sharma murder case, and was also a member of the Delhi Legal Services Authority. She was elevated as a judge of the Delhi High Court in 2009, and she's back in our ranks now as a senior advocate practicing regularly before the Supreme Court of India. And I think I'm really looking forward because just before this session began, we had an exchange, and she said she's been deeply studying the BNSS and its various parameters. Our final speaker is going to be Dr. Kumar Askan Pandey, who's an associate professor at RML University. He's written extremely widely on the subject and updated and written several textbooks. His rich experience covers, amongst other things, having authored and revised 5 textbooks on criminal law, the law of evidence, juvenile justice, published by leading Indian publishers like EBC and CLP. And his latest publications include Apprehension and Bail of CICL Procedure and Practice, Child Victim vis-a-vis Children Offender, Exploring Linkages Between the Age of Consent and Minimum Age of Criminal Responsibility. So you can see that this is truly a very rich and varied and experienced panel. Finally, Srinivas, who introduced me, is a young advocate I count him amongst our ranks in the Bar Association of India. Now, without further ado, I call on our first speaker, Mr. Vikramjit Banerjee, to address you either from the podium preferably, but we can do it from the desk as well. And I request you to sort of greet and welcome him in the traditional manner.
Thank you. Thank you, Shyam, for that wonderful introduction. Mr. Shamdevan, Mr. Srinivas, Mr. Acharji, the Honorable Justice Mukta Gupta, Mr. Kumar Pandey, and friends. When I was put onto this panel and I saw the list which was sent to me on email, I was like completely intimidated because these are these very eminent people on criminal law, and my experience of criminal law is as Napoleon said, some are born great, some others become great, still others have greatness thrust upon them. So mine is the last case, is when I became Additional Solicitor General. You know, I came from a background of largely original side practice in Kolkata. And when I became Additional Solicitor General, I was told that there are two things which you have to do, two subjects which you have to handle, which I knew very little about. One is tax and the other is criminal law. So that's my experience. It's been learning on the job. So, you know, if I make any mistakes, and I've appeared a number of times before Honorable Justice Gupta, and she has, you know, on various occasions corrected me as to my perspectives on the law. So I'm very, very careful, and I may be wrong. So, but these are my perspectives on the new act. So I apologize in anticipation. And coming to the question at hand, I think there is no doubt that the criminal laws needed a relook. Let's not be under any debate or any, you know, some people have, and I've heard this being said, that it's old, it's worked. Some people are even saying that if the British applied it all over the Commonwealth, starting from Africa to Malaysia, and everybody still applies it, what's wrong with it? I think especially the Criminal Procedure Code, IPC required updates, and that's happened as well, because it has happened across the law everywhere, all across wherever the criminal law jurisdiction exists because of time. But the Criminal Procedure Code specially required huge updating. The reason why this huge updating was required, because procedure requires updating from time to time. And it's not the first time where Criminal Procedure Code was being updated. In 1973, there was this sort of, once more, there was this updating. The IPC is very old, but in 1973, I think there was a updating attempt to the Criminal Procedure Code. Not very much changes, but substantial changes as well. Now, why do we need these changes? Number one, the world has changed. Technology has changed tremendously. When the Criminal Procedure Code, the original Criminal Procedure Code was framed, it was the world of the telegraph. It was 1857. When you recall this, that 1857, the telegraph was used to indicate to the British cantonment in Delhi from Meerut that the soldiers had risen against the British. So it was, that technology is that old. And today we have internet. Today we have audiovisual technology. Today we have technology which is almost completely different. We live in a completely different world. The society that we live in has changed completely. And not only in India, but all across the world. Now, the other question, and which I will address in detail, is all of us know that we worked this procedure. We worked this procedure even from 1973. There are literally 50 years old. So that last major changes was like 50 years old. So to make substantial changes, the law has changed. The procedures have changed. The requirements have changed. The society has changed. The law has been worked on. And this is going to be my last suggestion, saying that whatever the act is, it will happen, but we'll have to work on the law. There are concerns which we have come across while addressing the procedure code. I think one of the major concerns which has been often discussed is that sometimes the process becomes the punishment. And it's also been discussed largely that we need to recenter the law to have human rights perspectives, especially in criminal procedure. There have been, we've throughout the last 50 years, we've had various different suggestions, including, I think, the Malimat Committee, which sort of discussed as to what changes of procedure could be done. And the last one was, I think, Mr. Ranveer Singh's committee, who was a teacher of mine, who suggested certain changes in the law. So, it's not that it's a new thing. It's not that it's something which the government thought out of the hat. It is something which was a long time coming, and I think it was discussed in great detail, and changes have been incorporated. Some would say, completely a relook at the law was required, and that is what has happened. One issue which I was flagging is, the biggest thing, and this I'll stress on as to when I discuss the provisions of the new code, is that technology had to be incorporated into the process. The old process did not have space for technology. Because the technology has completely changed. You can now in real time, for example, record evidence. You can have, and we saw during the pandemic, we could have courts and being conducted through audiovisual means. We've had, and I've seen some of these trials in Britain happening through audiovisual means. I've seen people being brought in, cross-examinations being done. So, we had to, any new procedure which sort of tries to govern New India, which, had to incorporate these things. So it's extremely important that that be incorporated. So that is one of the things. The second is, there was a requirement, and I think it's a genuine requirement, that the code needed to be recentered. And recentered on a human rights perspective, to the extent that the process, as I said, as I discussed, does not become the punishment. So there had to be some sort of a timelines which had to be fixed on which certain things could be done. I think these are the two major takeaways, according to me, broadly, which the Act changes. One is it incorporates technology into the criminal judicial process, and two, it sort of fixes a timeline on which things can be done. But the question is, of course, whether those timelines are going to be strictly adhered to or not. That depends upon the courts. And as I always say that, the Act has to be worked out. It's still a work in progress. An Act is an Act, as we all know as lawyers, as litigation lawyers. It needs and time to work it out. And a lot of things will happen. We will realize sometimes it works, sometimes it doesn't work. But I think that the Act is a great, great idea. You also have to, in this, you also have to realize, and something which is not discussed and possibly not discussed in places similarly situated, is that both the Criminal Procedure Code and the IPC is in some ways a product of colonial approach to police, colonial approach to the state. So it required from a colonial approach to a nationalist, for the want of a better word, national. I know in some circles nationalism flashes red lights, but I think that it's important that we sort of take it out, and the penal code has reflected some of these changes. So that it required a reframing of the Act so that it makes it more receptive to the individual concerned, which takes care of both the accused as well as the person who is subject to the trial. Now, I will just, sort of towards the second part, I will flag some of the broad provisions which I think address these issues. A lot of wide changes have been made on different aspects of the law and process, which have, according to me, been changed and updated. The first aspect, as I marked, was bringing in technology. I think if you see Section 2A and I, which introduces audiovisual and electronic communication, saying that you can do that, recognizes that. Section 37 clearly indicates that the name and address of the arrested be prominently displayed on digital portals of the police station as well as the district headquarters. Now, all of us know who've been involved in, address it, and sometimes I'm on the other side, so that if a person is arrested, you know that the person arrested. So that goes right out immediately. So I think that's a great step. I think a lot of questions, and we face a lot of times, I think, those who come to the court saying that whether they don't know whether the person has been arrested or not. So once a person is arrested, his name goes out, publicly. Two, it recognizes the electronic mode of communication for identification of the accused, for serving of summons, for recording of statements of the accused or witnesses. Interestingly, it says that whenever you are on search and seizure, whenever you sort of compile the search and seizure, you get it audiovisually recorded. And it says that for offenses punishable more than 7 years, forensic evidence and videography of evidence collection is mandatory. These are things which I think in some ways we all talk about substantive law and substantive justice and substantive laws being protecting against human rights violations. But according to me, and I think most criminal lawyers will agree, it's the process which protects the rights of the accused. So it's very important to have a process which is fair and a process which is transparent. The second aspect is about the timelines. If that's a hurry, I'll just go through it. I think there are a large number of timelines have been fixed on large number of issues, including police to inform victim complainant about the progress of investigation. There is timelines finished for conduct of investigation during trial. There are timelines to file discharge applications. The timelines about judgments to be given. Summary trials have been allowed in all cases where imprisonment is less than 3 years. No more than 2 adjournments, which is, I think, would be applicable to us. Judgment to be uploaded on the portal within 7 days. Again, something which, as lawyers, which we feel is very important. And timelines for, have been also for mercy petitions, because we know that there are a lot of games which are played. So that has been fixed. Of course, bail has now been defined, and anticipatory bail. Anticipatory bail, as all of us know, had very specific grounds. That has been removed. Overall, I think it was extremely important to make these changes, and it's very good that these changes have come. I laud the act. As I say, the wordings of the act, the name of the act itself, I think is a reflection of us trying to come out of our colonial mentality and hangover. It's in an Indian language, and it's in the official language of the country, and so therefore, to that extent, it's a change. I think this is the first time in a Union Act has an Indian name. I may stand corrected, but that's my knowledge of the subject. Last, and this is what I'm saying again and again and over again, this act has to be worked out, and there would be no act, no legislation is perfect, and it will have to be worked out by the courts. And whether the courts, to what extent the edges are evened out depends upon the courts. And the balance of the accused and the victim which will be struck will depend on the jurisprudence which comes out of that. Acts are welcome, but it requires working out. Let's see once it comes into effect. Thank you very much.
Thank you, Vikramjit. May I request Mr. Acharya to address us, either from the podium or from here? From the podium. Mr. Acharya's paper has been circulated to each one of you, and you will find it in your email inbox. So that's a beginning, but I don't want to reveal any more, and I request you to listen very carefully to Mr. Acharya's presentation. Thank you.
This will be here. Mr. President, other distinguished panelists, and all my friends. First of all, I thank Bar Association of India for giving me this opportunity of participating in this program. And I feel it is a great privilege to participate in this function, which is presided over by the President of the Bar Association, by Asian Bar Association, Sri Sham Diwan. Now coming to the subject, BNSS. Let me start with the title of the enactment. It says Bharatiya Nagarik Suraksha Sanhita. Now actually, as I find, 90% of the provisions here are exactly what were there in the Criminal Procedure Code 1973. There are few changes effected, some deletions, some additions. Barring that, I don't find any major change in the procedure either from the code or otherwise. And you can't say it is a very old code, colonial legacy. In fact, the Criminal Procedure Code 1973 was enacted 25 years after independence, and after there were at least 4 reports of the Law Commission of India and some experts committees. Then this 1973 Act was enacted. Now the very preamble says it is an act to consolidate and amend the law relating to criminal procedure. But the title is nothing to do with the criminal or procedure. It says, if my knowledge of Hindi is not limited, it virtually means Indian Citizens Protection Code. In fact, the entire code, there is no protection of the citizens is involved. It is a criminal procedure code. So I don't know what is the need for having this. Merely by saying it is protection of the citizens, you don't get any protection. The only change I find is the title is in Hindi, and we from South find it rather difficult to understand. I am not against Hindi. In fact, I am a great lover of Hindi. I studied Hindi from third standard up to graduation, and I passed Hindi in second class. But what I am saying is, these changes were wholly unnecessary. Secondly, the changes which have been effected could have been easily done by amending the 73 code. It was wholly unnecessary to have changed all the sections from one to the other, because whether it is the judges or lawyers or the police, you are all very familiar with the various provisions. A private complaint, 200, FIR, 154, all these sections, you know it well. Now, these are all changed. The point is, it will take another 25 years for even the experienced lawyers and police to know which is the corresponding provision which is there now. So this change is not in the interest of the criminal justice system. The object of speedy trial is not achieved by this. On the other hand, it places obstacles in the way of criminal justice system. Now you see, now supposing it is supposed to come into force on 1/7/1924. Immediately thereafter, whatever crime is reported to the station house officer will not be knowing which is the relevant section. He has to go to the table and see which is the corresponding provision and all that. All this was unnecessary. According to me, not more than 10% of changes have been effected. These could have been done by an amendment act so that the relevant provisions will be same. Wherever there is change, we can could have adopted the changes. Now, first coming to the question of FIR. Now, 154 was the section. Now it has become 173 in the Sanhita, new code. Now, as you all know, there was some difference of opinion as to whether when information of a cognizable offence is given to the station house officer, is he bound to register the case immediately, or could he hold some sort of a preliminary inquiry before registering it? This question was settled by the Supreme Court in the case of Lalita Kumari, in which they said that the SHO has no discretion. He should immediately register the FIR, and there is no question of any preliminary inquiry, except they spelt out a few contingencies where it's a dispute, matrimonial dispute, or Prevention of Corruption Act, where the information is about disproportionate asset, a preliminary inquiry could be held. And even that preliminary inquiry, Supreme Court made it very clear not to find out the veracity of the information, but only to find out if it discloses a cognizable offence. If it discloses, you are bound to do it. Now, a major change has been effected under the new Sanhita. It says if the punishment for the offence is between 3 years and 7 years, then SHO is given full power to decide whether to hold a preliminary inquiry or not. Only condition is he must get the approval of a rank of a officer of a rank of DSP, that's all. And this discretion is given. I fail to understand the requirement of such a preliminary inquiry. According to me, this discretion vested in the SHO to hold a preliminary inquiry or not to hold a preliminary inquiry will not only delay the whole process, but it will also give scope for more of corruption, even at that stage. It is our common knowledge that one of the reasons for corruption is where there is a discretion in an officer, there is scope for corruption. But if the discretion is reduced, then scope corruption is less. Here, every offence between 3 and 5 years, 7 years imprisonment, the SHO is given the discretion. The result is there will be approached by both the sides with regard to the result of the preliminary inquiry to be held or not. Therefore, according to me, this is a retrograde step to overcome the ratio in Lalita Kumari's case. This was wholly unnecessary. Another important aspect I fail to understand, what is this 3 years to 7 years. If they could have said below 7 years, any punishment, you can. Now there are large number of cognizable offences where the punishment is 2 years or 1 year. In those cases, no preliminary inquiry discretion is given. I don't understand the rationale for having this limit of 3 years. Therefore, according to me, this provision regarding preliminary inquiry has given scope for unnecessary delay. At least for 14 days, there will be delay in registering a case and discretion to the SHO to decide whether there is a prima facie case or not. Then it says, information orally or in writing was the earlier provision. Now they say orally or electronic communication. I don't find any need for electronic communication. If it is electronic communication, then the person who has sent the information should come to the station and put his signature on the statement within 3 days. Then only it will be registered. According to me, one welcome change that they have made is the information to any police station, you are bound to register a FIR. It need not be the station which has got jurisdiction in the matter. And this was the law all through. Even when I was a prosecutor in Mangalore in the year 1962-63 itself, the session judge wrote strictures on the police who refused to register a case saying that this is outside my jurisdiction. When he comes and asks where exactly is the offence, if it is on that side of the road or this side. If it is on that side, you go to that station. They said, you can't say that. Now it has been clarified. But it is only a clarification, nothing new about it. So, when you have a right to go and give information to the nearest station, according to me, this provision for electronic communication was wholly unnecessary and it will again delay the matter. And no object is served by having this electronic communication because you register it only after, within 3 days if he comes. Now we are all aware of this hoax calls, threatening bomb and all such things. Now, a first information regarding a cognizable offence must be by a responsible person about the authenticity of the information. So this provision regarding electronic communication was, according to me, wholly unnecessary. It should be either oral or in writing, and immediately his signature must be taken and a copy has to be given to the informant. That is the requirement of law. Then next is about the remand, police remand. As we know, remand is one to the custody of the police, the other is judicial remand. Now the provision is that the remand to the police could be only up to a period of 15 days. That 15 days is retained. But under the old code, that period of 15 days is immediately after the arrest and not beyond that. Within 15 days itself it should be done. But now they have amended to say that it could be during the duration of the investigation, which could go on for 60 days or 90 days, they say, and in some cases, which is not recognized here, it goes up to even 180 days, NDPS Act, etc. So till then, there is a scope for the police to seek a remand intermittently but the total should be 15 days. Of course, some are of the view that this 15 days is enhanced to 60 days or 90 days. It is not so. The total remand to the police could be only total of 15 days, but it could be at any time till the investigation is over. This, according to me, is a retrograde step. The earlier position was better. This doesn't help. In substance, what I say is the present code, if you analyze, it gives more power to the police than protection to the citizens or the accused. That is the point. Then another important aspect is about further investigation after the filing of the charge sheet. Now, under the 1973 code, section 173(8) provided for such further investigation. Now, earlier there was no such provision. It was introduced in the 73 Act, because if after the filing of the charge sheet, the police or the investigating agency finds some crucial clinching evidence, it should be able to gather it and file it before the court. Therefore, this provision is made that you can have further investigation and file a supplementary report to help to strengthen the prosecution case. This provision is made. But in our practical experience, we have found that this provision is being used, mostly misused by the police for various reasons. In fact, in the case of Selvi Jayalalitha herself, at the stage when 313 statement of the accused was being recorded, after the prosecution evidence was closed with the 259 prosecution witnesses, suddenly she came to power again and became the chief minister. Immediately the DBSC, that is the local police of Tamil Nadu, who are the investigating agency, immediately they said, we want to further investigate because there is a direction from the chief secretary that there has been a lot of miscalculation and therefore we want to, and as prosecutor I said you can't do it at this stage, 313 statement is being recorded. Now there is no question. And the whole object was to help the accused to have a recalculation and say that in view of the further evidence she should be then, even though I refuse to seek time on that ground, the IO directly writes to the special judge, give us 6 weeks, we are going to further investigate and file a charge sheet. Ultimately, the High Court had to quash this further investigation held because it is patently it has been done to help the accused. So this way it is being misused. Only 2 years back in Bangalore, I had a case where a charge sheet for murder case is filed against 6 persons as the assailants. And long thereafter, a further supplementary charge sheet is filed with the further investigation saying that it is not these 6 accused but another 8 accused. They are added, 14 accused. Thereafter, after 2 years, another supplementary charge sheet is filed saying that one prominent politician, MLA, he has abetted it, therefore he is added as an accused. And this is done after 55 prosecution witnesses had been examined. This is how this provision for further investigation is misused. Now still that provision is retained, it's all right. But my point is, one important change made here is that if the trial has commenced, then you can't do further investigation without the permission of the court. This is a welcome change which is brought about, but according to me, it doesn't go far enough. In fact, the provision could have been made. Yeah. Yeah. Then, only one very important point I will touch upon. Regarding private complaints. According to me, the present provision of private complaint is virtually rendered negatory. As we all know, Section 200 is the provision under the code for a private complaint. Now it is Section 223. It says a magistrate having jurisdiction while taking cognizance of the offence on complaint shall examine on both the complainant and the witnesses present, and usual procedure. Then it says, this is a new provision added, one provision. Provided that no cognizance of an offence shall be taken by a magistrate without giving the accused an opportunity of being heard. As we all know, from 200, 202, 203, 204, the court will, the magistrate will consider the statement, and then either he will proceed or dismiss the complaint. At that stage, accused is not there. Even under the present code, 223 to 227, accused is not there. So how can the very first is a magistrate having jurisdiction while taking cognizance of the offence should examine the complainant on oath and his witnesses. But then the provision says he shall not take cognizance unless without giving an opportunity to the accused of being heard. Accused is not there. How can you give opportunity to an accused? And if you to say this provision gives the power to the magistrate to summon the accused, it will be absurd. Even without knowing what the complainant's case is, without recording his statement, where is the question of calling upon the accused to have his say in the matter? So this is total non-application of mind. And worst still is, according to me, even if you feel that one opportunity should be given to the accused to have his say in the matter, it should be at the later stage of 227. Instead of that, in the beginning itself, before taking cognizance, you give the accused an opportunity of being heard, is something that is totally not acceptable, not practicable. I have explained it in detail in my note. This clearly shows non-application of mind. So just to conclude, what I respectfully submit is that even now it is not too late in the day. The present enactment changes have been effected without due deliberation and examination and total non-application of mind, as I pointed out. Therefore, it is better that the implementation of this enactment is postponed so that all will be familiar with the new provisions which they bring about. And I submit that whatever changes have been made between the code and the Sanhita, they could be done by amending the 73 code itself, retaining the very sections instead of complicating matters by having different sections is what I feel is the requirement. Thank you very much.
Thank you very much, Mr. Acharya. May I request Mukta Gupta, please, to share her insights, and please take as much time as you like. No, just please take your full 10, 15 minutes, whatever.
Mr. Nariman, Vice President, Bar Association of India, Mr. Vikramjit Banerjee, Additional Solicitor General, Mr. V.B. Acharya, Senior Advocate, Mr. Kumar Akash Pandey, Assistant Professor, Mr. Srinivas, Advocate, Mr. Nitin Thakkar, Senior Advocate, all other senior advocates over here, legal luminaries, jurists, academicians, and my young friends. Good morning to all of you, and thank you for inviting me to express my views on these 3 new enactments which are to come into force on the 1st of July 2024. Undoubtedly, law is the embodiment of societal demand, and it evolves as per the need of society. And efficiency of any law depends on 3 factors. Firstly, how the legislature legislates it. Secondly, how the judiciary interprets it. And thirdly, how the executive implements it. Now, in fact, these enactments are required to answer all these 3 stages. But what we find is 90% of the provisions are verbatim the same as the earlier enactments, except instead of the section, now we say it's a clause. They have been rearranged, so we'll just keep comparing which was the earlier and which is the old, and we'll say instead of section, we'll now start saying clause. Like if cheating, there were 5 offenses, we will, instead of saying 420, 421 and all, they're all clubbed in one subsection, one subclause 1, subclause 2, subclause 3. So these are, in fact, I'm in total agreement with Mr. Acharya that if there could be amendments brought to these 3 codes, that would have been far more effective. And I thought there was more deliberation required, more thinking required, more exercise required before bringing these 10% of changes which have been there. There is a welcome step in these in BNSS where section 176(3) provides that for any offense which is beyond 7 years, the crime scene collection has to be by the forensic experts. And there is a mandate given that in 5 years all states will have their forensic evidence collection compulsorily. No, by merely providing this does not really help that we'll be able to do forensic evidence. For a state like Delhi, I know at one stage when I was a standing counsel, a writ petition was filed and we ensured that there is a mobile crime team in each district, and specially vacuum analyzers, sweepers, etc. were ordered, and that they will be investigating. 4 years down the line, one day I had an occasion to see how these mobile crime teams were working, and still found that they were collecting the fingerprints by putting the powder and taking it out. So ultimately, unless this comes in the practical domain, this will not help us. Contemporaneously, they have made provisions under section 185 and 105 of the BNSS, which provide that the search should be audio-videographed. Now it's very essential. There was, in fact, a demand for a long time, because witness may change, but the fact if the videography of the incident is there with the court or the crime scene is there before the court, it really helps. But what was actually required, this otherwise could have been done without an amendment, but what was actually required by the legislator to have done is to deal with the issues of its admissibility, veracity, how to ensure time stamping and all that, which has not at all been answered in these enactments. Today, can you just say anybody using an electronic evidence, simpliciter gives a 65B certificates, it becomes admissible, and 99.9% there is no inquiry beyond it for the veracity of that document, electronic document. Because we don't have that systems in place, we don't have that systems in enactment. And mind you, the technology is progressing very fast. Today there is a provision in this that the charge sheet, all documents will be supplied electronically. I have dealt with cases at the appellate stage where documents were there in the CD, and when it came for hearing at the appellate stage, we didn't have any computers which could read those CDs. This is how the technology gallops. So these are the actual answers which we need to give. Even without these amendments, audio videography, if it was done, that was admissible. See, what is the scope of investigation? CRPC never defined, and it can never be defined. Because in every case, the fact situation would demand a different way, technique to collect the evidence. You can have some standard facts, some standard, but it all depends on the facts of each case. By defining certain clauses, you do more harm than benefit to those provisions. And what was actually required to be defined as to the efficacy, the veracity of these and how to deal with these evidence has not been done. Now, I'll just show a practical example. Today, I think mobile phone is the first thing which is asked in any investigation. Now, obviously, there are concerns of right to privacy and right to investigation. That apart, does the answer lie in giving the entire mobile phone to the police investigating agency? Once it is seized, it's seized for the investigation trial, and the person will now have to start up afresh his entire mobile data. Everything goes today. Everybody's data is there in the mobile itself. I remember today they used to seize the CCTVs. So what they would do is take the DVR of the CCTV. Now, none of these enactments answer how to deal with this scientific evidence. I would often ask them, then I made them lay down the guidelines that how can you take away the DVR of a third person who has invested CCTV for his security, because you need in the investigation. Either you give him a substitute DVR, that's a state's responsibility. It is not for that common man to bear the cost of your investigations. We don't have any mechanism, none of the police officers is trained to take the mirror images on the spot. You take the mirror images and work on it. When you asked that what is the investigation done, we seized this instrument, now it's been sent to forensic, that report will come after 6 months, then you will get to know whether actually any offense has been committed or not. This is especially so true when the allegations are that they took my morphed photographs or some videos and all, and they have misused it. Now for 6 months you have no material because the police seizes a mobile phone and keeps it in custody and sends it to the FSL. We didn't even open and see, because if they open, then the allegation will be that it is tempered and all. What was required to be answered for electronic evidence was the mechanism to take this evidence, mechanism how to deal with it, how to ensure the efficacy of it, and that there is no tampering with it, which has not at all been answered in this. I am grateful to Mr. Acharya, who said that yes, zero FIR and preliminary investigation. In fact, if you have our old CRPC, which is still functional, it does not tell you where that, it only says under 154, on receipt of an information, the SHO will register the FIR, the information. It does not say that whether the offense took place here or somewhere else. Only when it is an application and filed under section 156(3), it was said that the magistrate under whose local jurisdiction the offence was committed. So the jurisdiction issue came only at the stage of 156(3). Undoubtedly, providing for a preliminary inquiry is incorrect. That's just in the teeth of the decision in Lalita Kumari's case, and giving more powers to the police. But what is more interesting in this 173 BNSS is you can not only register the FIR in another jurisdiction with the permission of the ACP or the DSP, you can investigate, arrest, do everything in your state. So supposing our country has a federal structure, supposing an offence is committed in Delhi, there may be a dispute between two police stations whether X or Y, but that may not be so material. Imagine an offence committed in Delhi, the complainant goes to a remote part of the country, lodges an FIR, the concerned DSP gives the permission to investigate after preliminary inquiry, and then the person will be tried there. See the consequences of that. That may be actually one of the most challenging issues which we'll have to face after 1st July. Now, undoubtedly, colonial laws had to give way and our national laws should come into place. But let me tell you, there's been serious regressions in this enactment and more powers to police state. Earlier, if somebody was to be handcuffed, it was required of the police officer to move an application before the magistrate who would give permission. Today, section 43(3) of the BNSS provides a discretion with the police officer to use handcuff while making arrest, keeping in view the nature and gravity of offence, such as habitual offender, one who has escaped, who has committed organized crime, terrorist, drug related, illegal possession of arms, ammunition, murder, rape, POXO, etc. Now, in this thing, I'll just give you an example. Terrorist Act, we know, first we had the TADA, then POTA, now it's UAPA. Now, verbatim, UAPA's Terrorist Act has been brought as section 113 of the BNS, that's equivalent to IPC. Organized crime, which is an offence under the MCOCA, which is extended to Delhi, Maharashtra Control of Crimes Act, extended to Delhi, Gujarat Control of Crimes Act, then AP COCA, some of the states have it, has been now provided as an offence under the IPC under section 111 and section 112, which says petty organized crimes. Now what? You have a special enactment, you have a general enactment. In the special enactments, there were some safeguards in the sense only a senior officer could direct. There were some checks and balances, though the rigors of bail were serious. Now here, once they come in the IPC, any police officer come and arrest you, register the FIR under organized crime, under the Terrorist Act, and follow the procedure under CRPC, which includes 43(3) BNSS, which including his discretion to handcuff you. Now, more than one charge sheet for an offence of cheating, and a person is at the discretion of the police officer liable to be taken and paraded in handcuffs. So that may be one of the situations. Now, there is a salutary provision 197 CRPC, and repeatedly Supreme Court has said it's not an idle formality. Section 218 of the BNSS provides that if the sanction is not given within 120 days, it will be deemed to have been granted. Now, all the safeguards of the accused under 197, that there was no application of mind or it's by an incompetent authority, is gone, and merely because, and no order means there is a sanction. Firstly, there had to be a positive order. Today, no order of sanction means there is a sanction. Then coming to the, undoubtedly, as the solicitor said, we have witness protection incorporated. But unless we have a complete mechanism how to grant witness protection, merely by Section 392 mandating preparation and notification of witness protection scheme will not help. See, in other countries there are Witness Protection Act. Witness protection is a very important aspect of a criminal trial. I remember the first time in India witness protection scheme was laid down by the Delhi High Court, given to Neelam Katara in the case of Nitish Katara murder case. That was the first time when they said any person where the police officer feels or the person feels, he will apply. The Legal Services Authority secretary was made the member secretary, who will apply his mind and then grant protection accordingly. Now, merely giving a 392 mandate, prepare, notify, witness protection scheme, that doesn't help, because it is a very varied subject. Protection to witnesses is required at various levels in various forms. It's not merely a police protection. I have dealt with cases where each of the witness had police protection throughout the trial and each one of them turned hostile. So there are ways and means how to deal with it, and this by mere enacting Section 392 CRPC, mandating, preparing and notifying witness protection schemes is, I would say, a lip sympathy. We need to really work on this witness protection, maybe by bringing an act if we have to move forward. Then just one more thing which I would like to add up, that in these changes which have been brought up, one of the changes which Mr. Acharya said was that you can now have the custody. It is for the first 40 or 60 days that any time police custody can be had further, but for a total of 15 days. Now the pitfall of it is that we will, today once the police custody was over, the accused was said, now whatever you wanted to recover, you can have recovered. I am entitled to bail. That is a valuable right which I don't think which will have to be looked into. There are undoubtedly some good changes, but I thought that those changes need to be worked upon, and as Mr. Acharya said, that we can just we should have worked on them as an amendment and wherever necessary brought separate enactments for that. These are, I think, some of the changes which came to my mind and I thought I must share with you, which were beyond what Mr. Vikramjit Sen and Mr. Banerjee and Mr. Acharya said. Thank you very much for giving me this opportunity. Thank you.
Thank you very much, Mukta. And now may I request Professor Kumar Askan Pandey to share his thoughts. Thank you.
Thank you very much, and Mr. Sham Diwan chairing this very important panel discussion. Justice Mukta Gupta, Mr. Vikramjit, Mr. Acharya, Mr. Srinivas, and other distinguished members of the legal fraternity who are available on this Sunday morning here. I'm grateful to the organizers for providing me with this great opportunity to give some insight that I have as far as this new law that would be unfolding from 1st of July 2024, Bharatiya Nagarik Suraksha Sanhita is concerned. Because most of the important and controversial issues have already been addressed by other panelists. So I'll be touching on certain issues that are unleft, rather left untouched. Let me start with this information that these laws are not what the committee that was meant to draft these laws had proposed. The last 2 days of discussions amongst the committee members were held at Dr. Ram Manohar Lohia National University, where I come from, and I was fortunate to coordinate those discussions. So I know that what was proposed and what we have that would be implemented from July 1, 2024. The drafts that were submitted certainly did not change the structure. Often we do not attach much importance to the figures and numbers in the legislations, but then these legislations, the IPC, the CRPC, the Indian Evidence Act, they have been with us for the past 150, 160 years. And we are so familiar with the certain numbers that immediately once we hear those numbers, we visualize that what kind of provision we are talking about. Same as with the CRPC as well. Mr. Acharya very rightly pointed out that without changing the sequence, without changing the number, whatever modifications were required, whatever changes were required, could have been very easily inserted into that scheme. Now the issue is that CRPC, or for that matter the Bharatiya Nagarik Suraksha Sanhita, the BNSS, is as much of a concern for lawyers, judges, as it is for the police officers, and that too for the SHOs and even the lower rung police officers. They are so well versed, they are so conversant with these numbers. You just say 161, you just say 154, you just say 164, 40, and they know that what provision of CRPC they are supposed to look into. Now it's very difficult because they would be also dealing with the pending cases that would be dealt in accordance with the existing CRPC, and from July 1, 2024 they would be referring to the new provisions. Most of the new provisions are in the form of clauses. There are no independent provisions in all, so that's going to lead to utter chaos. This is what I visualize, and this is my gut feeling. Now everyone spoke on the title of that and the need to have this in Hindi. Now I have something more to add to that. Now this criminal procedure that we have with the title BNSS uses the word Bharatiya Nagarik Suraksha Sanhita. Nagarik, when translated into English, means a citizen. Now this procedural law is as much for the protection of a non-citizen as it is for the protection of a citizen. We know that even alien enemies, even those who attacked the parliament, even those who were involved in other terrorist activities, non-citizens, they were also accorded fair trial as per the provisions of CRPC. That fairness is due to everyone who is accused of an offence under the Bharatiya Nagarik, Bharatiya Nyaya Sanhita, of course, but that that title is something that they could have a better word for. Now, everyone spoke on this EFIR thing. In fact, I was fortunate to be part of one consultation that the Law Commission of India had organized recently. And pursuant to that, Law Commission of India had submitted its recommendation number 284, if I may recall correctly, on EFIR. The provision as far as EFIR is concerned, that's certainly a welcome provision. But then there's nothing to prevent the misuse of it. As Mr. Acharya very rightly pointed out that there have been instances when people would be filing frivolous complaints, but those frivolous complaints would be leading to a lot of problem and all for those against whom those complaints are made. Now, this provision of EFIR that would be opening floodgates of such frivolous complaints, and there is nothing in CRPC, that there is nothing in the Bharatiya Nagarik Suraksha Sanhita that would be in a position to keep a check on that. Another anomaly that I find as far as EFIR is concerned is that the person making that complaint has to sign it within 3 days, only then it would be taken on record. But we all know that the moment police receives an information, that has to be taken on record. Now, that could be related to a cognizable offense. If it relates to cognizable offense, it must be recorded as an FIR. If it relates to a non-cognizable offense, even then it has to be taken on record. We know that police keeps two kind of diaries, one that we call the daily diary. The daily diary must contain every information that police receives from whatever means. So this is a little anomalous that it would be taken on record. Probably they wanted to say that FIR would be registered only after that information is signed by the informant within 3 days. That discretion that has been given to the police officer in those cases where the offense is punishable with 3+ years of imprisonment, but up to 7 years of imprisonment, that also is problematic, and I'll be giving you one example. We all know that Lalita Kumari's mandate has been diluted as far as this particular provision in BNSS is concerned. If you see section 106 of Bharatiya Nyaya Sanhita, section 106 of Bharatiya Nyaya Sanhita corresponds to section 304 capital A of IPC. Now, in Lalita Kumari, the Constitution bench of the Supreme Court had carved certain exceptions where the police may conduct what we call the preliminary inquiry. Now, medical negligence cases were such where the police would be conducting PE before registering an FIR. There were other categories and other offences as well in Lalita Kumari case listed where the police may indulge in, the police may conduct PE, medical negligence being one. When you read the punishment provision as far as section 106 clause 1 is concerned, now there are two clauses. One that would not be implemented from July 1, 2024. We all know that a false narrative was built by certain vested interests that hit and run cases would be sort of creating a lot of havoc, this and that. So 106.2 is not going to be implemented, but 106 clause 2 would not be there on the statute book from July 1, 2024. 106.1 would be implemented. Now, for medical negligence, the punishment is still 2 years. If a doctor is found to be negligent in performing some operation that leads to death of his patient, the punishment would be 2 years. Other cases of negligence that lead to loss of a human life would be punishable with 5 years imprisonment. 5 years imprisonment. So this discretion that has been vested in the police officer would be applicable in ordinary cases of negligence leading to ordinary in the sense that case of negligence in which a non-medical professional is involved leading to 5 years imprisonment. The police officer would be using his discretion, but when it comes to medical negligence cases, certainly there is no discretion left in the police officer. Now that is a little anomaly that I could think of. The other provision which I find disturbing, if I may use that term, is the provision contained in section 356 of Bharatiya Nagarik Suraksha Sanhita that provides for trial in absentia. Now, we understand, we know that a fair trial is a facet of human rights. A fair trial is implicit in right to life and personal liberty flowing from Article 21 and other fundamental rights provisions of partly of the Constitution. Now, when an accused is tried in absentia, what is denied is that fair trial. And there are cases, there are decisions delivered by the Supreme Court where the Supreme Court has categorically held that it's not a mere fair trial, rather it's the quality of fair trial, where the quality of legal aid would also be very, very crucial, that every accused, even if he has been accused of the most heinous and the most serious offences, is entitled to. Now, while lawyers represent their clients, they seek instructions. What line of defense they have to sort of pursue, that all depends on the communication, regular communication and instructions that they receive from their clients. Now, that would be lacking, that would be that would be absent in such cases. Therefore, this provision 356, if challenged in the Supreme Court, I believe that would be found to be unconstitutional. I understand that I started the time when this whole session was to be wrapped up. So these were a few issues that I thought that I must flag and must present in front of the legal fraternity to ponder over. Thank you very much once again for this wonderful opportunity. Thank you.
Thank you all, distinguished speakers and our listeners. I'm sure we are going to evolve one of the best criminal laws in the coming years. Whatever the anomalies, we have to face them. And I'm going to foresee that a best criminal procedure system will be a model system, will be evolved, which will be a model one for the whole world or other countries to emulate. Thank you all.
So I draw this session to a close, and I'm going to request each one of you to thank our eminent panel in the traditional way. But before I do that, I thought, since we are sort of in the process of decolonizing, I put into my phone and asked AI, what is cricket in Hindi? And the answer which pops up is Gol Gattam Lakkat Pattam De Danadan Pratiyogita. So with that, let us prepare for decolonizing, and please join me in thanking our eminent panel. Thank you, sir. Thank you very much.